my name is John Steenhof. I am the principal lawyer at the Human Rights Law Alliance, which is an Australian not-for-profit law firm. We're based in Canberra. We act for parties in all states and territories in litigation and in advocacy relating to freedom of religion and freedom of thought, speech, and conscience. We not only act in Australia, but we often make submissions in all areas of the Commonwealth, including New Zealand. I'm also a former resident of New Zealand, so it's wonderful to hear the beautiful accent, and I want to say kia ora to everybody. Human Rights Law Alliance strongly opposes the New Zealand Conversion Practices Prohibition Legislation Bill for the reasons set out in our submission. We've had a lot of experience with conversion prohibition legislation, which has been passed here in Australia in the states of Queensland and in Victoria, and also in the Australian Capital Territory, the ACT. We believe the bill is a dangerous piece of legislation and unprecedented in the suppression of fundamental human rights and freedoms. And we've set out the main reasons why we think this bill is deeply flawed and should be rejected. Firstly, it's a solution that's in search of a problem. As stated in the Justice Department's regulatory impact statement, there is very little evidence of what is loosely termed conversion therapy taking place at all in New Zealand. And so there is no demonstrated need for this kind of broad and overarching legislation that has such a disproportionate impact, not just on professionals and health practitioners, but it reaches into the very homes of everyday average New Zealanders. The legislation is also deficient because it legislates contentious ideology, particularly in relation to transgenderism, when even within the LGBTQ community, there is a broad spectrum of views about these issues and how people should be able to speak about them and influence others about them. It's going to severely undermine the ability of parents and health practitioners to be able to make decisions based on the particular needs, not just of children, but of adults. It's unprecedented in the way that it even will take effect if a person genuinely wants to undergo particular treatment or have particular help with desires and with orientation issues that they face, because consent is no defense to a criminal charge. It's fundamentally inconsistent with foundational human rights in the New Zealand Bill of Rights Act, and it's excessive. No one, I think, will argue that antiquated and abandoned aversion therapies that involved electric shocks and other types of physical stimuli to try to deal with sexual orientation or gender identity are acceptable. Indeed, they're not acceptable. They've certainly never been practiced by religious communities and have been only really practiced in secular counseling therapies of the 1950s and 60s, and are long outdated and never used. To the extent that there is an issue with aversion therapies, then the Act should be limited to applying to those therapies. And the last point, I think, and probably the most important, is that it disenfranchises and it dehumanizes members of the LGBTQ community who are seeking counseling and medical care to treat gender dysphoria and oftentimes unwanted same-sex attraction. In our work in Australia, we have had contact with and worked alongside people whose identities will be erased by this act. There's no question that people who want to live their lives celebrating and in a transgender identity or a sexual orientation of their choice should be free to do so without harassment. The problem comes is when you have people who struggle with attractions that they do not want to follow up on, or with gender dysphoria, which the cause may not be their gender identity. This law will criminalize anyone being able to help those people adult people in New Zealand, real people who have found real flourishing, and they have found benefits from being able to engage in non-coercive treatments, talk therapies, psychoanalytic techniques, which have genuinely helped them to live free and vibrant and full lives. The bill overreaches in the way that it suggests that those people don't exist and shouldn't be able to get the real help that they want. People will be scared by the prospect of criminalization under this bill because of the broad definitions that the bill uses for both conversion therapy and for the harms that might result. I don't want to take up too much time, and I want to leave time for questioning. That basically gives an overview of the submission, and the details are in our submission. I'm more than happy to take some questions about my submission.
Thank you, John. We have two questions for you. First, Dr. Elizabeth Kerekere.
Kia ora, John. Thank you for your submission. I'm interested that if you're a human rights organisation, that you appear to, though, have some incorrect information. We have recent research in New Zealand showing that people are being subject to a range of conversion practices, that this is happening across the country right now. So since the bill enables people to, and the goal is to enable people to have open conversations, why do you think it precludes? Why do you think, given we have research, we have the testimony of hundreds and hundreds of people who have experienced conversion therapy. Why do you think it doesn't exist? And B, why do you think this bill precludes anybody from seeking the help that they want?
Thank you, Dr. Kerekere. I was referring to the Justice Department's regulatory impact statement, which talked about the lack of evidence of conversion therapy taking place at all in New Zealand. I haven't seen any up-to-date New Zealand research which shows the prevalence of the so-called conversion therapy. And the difficulty is with the definition of conversion therapy itself, where the mere expression of disapproval, say, of certain gender expression or sexual orientation, say, by many of the religious faiths in New Zealand, is seen as being conversion therapy in and of itself. We certainly have Australian research where after some extensive research, it was only 30 stories that were found of people who had alleged to have suffered conversion therapy. This is in a report out of La Trobe University, which is widely regarded to be the only research done in this field in Australia. So out of all of Australia, there were 30 stories, and of those stories, 28 involved persons who had undergone non-aversion counselling, which they subsequently regretted, but which they entered into in a fully. They were when they took that therapy, they were fully consenting to it. And so if the Australian experience is anything to go by, this is not a widespread practice, and research has not established that there is this practice going on with hundreds of people, certainly not in Australia, and I would expect not in New Zealand, but I would love to read that research.
Thank you. We've got another question from Louisa Wall.
Tēnā koe, John. Thank you for contributing to what is a very important discussion in New Zealand about the balance between, I guess, rights and freedoms guaranteed to us under our Bill of Rights Act and our Human Rights Act. And just for your information, I presume you've seen Crown Law's opinion that says the bill is consistent with our Bill of Rights. So really two questions. The first is actually your definition of human rights and the ability of LGBTIQ plus peoples to live in societies free from discrimination and to be seen as equal human beings and citizens of our respective countries. And the other question is really about who should be engaging in any form of therapy if it is needed by people. From our perspective, we obviously think it's health practitioners only who are registered and practice within their particular authority scope of practice.
Thank you. And John, I might just ask you to be brief with your answers as we're hitting the 10-minute mark.
Sure. So thank you, committee member. Firstly, on the question of the balance of human rights, there's a international understanding that all human rights are equal. There's an equal status of all human rights. In Western societies, there has been a patchwork protection of human rights and a particular focus on discrimination. And so that has meant that other rights have been subsumed underneath that within a human rights discourse. And human rights like the freedom of thought, speech and expression have long been well protected and so have often been neglected. The question of balance is not one I can meet in 10 minutes, but I'm not saying that we're talking about suppressing the valid rights of people to live as they want to. I think that this bill goes beyond allowing LGBTQ people of a particular persuasion to live how they want, and also would discriminate against LGBTQ people who want to deal in different ways with their sexual attractions and their gender confusion. And so thus goes too far. It legislates a narrow band of ideology on gender expression and doesn't fully represent the whole spectrum of the rainbow. So if you can remind me of the second part of your question, committee member, it would help.
Oh, just those who need help. The people that should be giving those people help should be health professionals or health practitioners only.
Sure, thank you. From the lived experiences of people who have found ways to deal with their unwanted same-sex attraction and issues of gender, they've been helped not only by clinical professionals, but also by registered counsellors and by spiritual advisors. People have found great freedom and have been able to live really fruitful lives after getting counsel from religious practitioners about the core tenets of religion as they relate to sexuality and identity. As long as they're not coerced, people should be able to, it should be free to seek whatever spiritual counsel they want, and this law would prevent them from doing that.